the jury came in there, and you'll recall the question was what to do about Van Brett Watkins, who was the trigger man in this killing, and has told two totally different stories about it. He's told first that he was hired by Ray Caruth to kill her, and indeed he did kill her. Then later, when he was locked up for that, he told a deputy in the jail that no, that's not what happened. Caruth had nothing to do with it. It was a drug deal that had gone bad. She made an obscene gesture to him when he approached her in the car, and he became so angry he killed her. Now, Walter Dewey, who is a prosecutor in New Jersey, this guy Watkins is radioactive to this prosecutor. But you think it wouldn't be the worst thing in the world for the prosecution to call him?
Well, they do have Kennedy, and that's what saves them from having to call Watkins here. But I don't know if I would be terrified of Watkins never having, of course, heard him or spoken to him. I don't know how bad or good he is. But the fact that he recants wouldn't necessarily deter me from calling him. Because if he takes this stand, and you do have to make deals with unsavory characters from time to time. We in prosecution understand that. Jurors understand that. And they expect him to be an unsavory character. But when he recants, at least under the law here in New Jersey, I can then introduce his statement, the statement of that he gives of events where he says Mr. Caruth was involved. Yeah. And really disassociate myself from Mr. Watkins and let the defense attorney crow about how honest Mr. Watkins has become now that he's recanted. And I can say, Mr. Watkins is an unsavory character, and he is a liar. He's lying to you now. When did he tell the truth? He told the truth in the beginning, and here you have a statement to prove it.
But I think one of the problems you would have if you put Van Brett Watkins on is there is independent corroboration of some of the things that Van Brett Watkins is going to say about a drug deal. You have calls which will suggest a drug deal. You have an expert which already testified that those calls are significant to prove that this was a drug deal. The kind of cars they were driving, the way they were driving them proves that this was a drug deal. So yeah, you can say Van Brett Watkins is a liar, but on the other hand, you have independent facts which are going to, in fact, confirm what Van Brett Watkins says, which is a version the prosecutor doesn't want.
I don't know if I would call him or not. I'm not going to really say that the prosecution is making a mistake here. They're probably right. But I don't have that overwhelming fear of Mr. Watkins' testimony that I think has been coming out.
You know, I think it may be very important to the prosecution that Watkins has a history of really kind of irrational, almost maniacal violence. I mean, he has been very violent to people for very, reasons that didn't justify it. And so here you have him telling this story about her flipping him off, and so he shoots her 4 times. He has a history that a juror might say, he's the kind of guy who might do that. Now, what do you think of the possibility that he's told the second story because he knows he's going to spend the rest of his life in prison, and he did that deliberately to poison the well, to keep the prosecutor from putting him on? He doesn't have to go to prison as a snitch.
I think that's a very strong possibility. Let's face it, people like Mr. Watkins do not like prosecutors, they do not like police, and they don't want to be snitches. And this is a common event that co-defendants will make statements against their brethren when they're in hot water, and then they'll recant, and they think that that's going to absolve them of having to testify.
But I would totally disagree with that, because I think the other argument is, and this is, I think, the more common sense argument, everybody in jail is going to do whatever they can to help themselves. And it's better for him to help himself to go to the prosecutor, offer the deal.
He's got his deal.
But to say what the prosecutor wants him to say. That's more helpful for him to say what the prosecutor wants him to say.
But he's got his 50 years. And now, without overtly getting on the stand in line and fouling up his deal, he does this wacky thing, and they're afraid to sit him down in the witness chair. Both sides are afraid to do it. Anyway, apparently there's a lot of reading going on.